What happens when parents challenge the inclusion of books in the school library and the school engages in their clearly stated procedures? How should we balance parents' rights with students' rights? Jamie, let's revisit how quickly a school board can reverse its own decision.
Let's do it. Well, this one wasn't as quick as the reversal in the Mahmoud case, which was like 24 hours. That was a quick one. This one, it took like a month.
Yeah. And this is the third example of a school board changing their mind that we've covered. So
Is it
Mahmoud,
really?
yeah, because the Tucson case, where they agreed to renew him and then a month later they non-renewed the principal.
Oh, okay. So we're
yeah,
starting
this
to
is
see a
our third
pattern
one.
here. Yeah.
I wonder if it's going to come out the same way.
Let's find out. Yeah. So today we are covering a case that was ruled on in April of this year, right? It's so pretty recent.
Mm-hmm.
It was out of New York. This case involved library books being challenged, a subsequent review process that took place, and a board decision to ultimately keep the books on the shelves.
Yeah.
Teachers and school leaders, this is a really good case, and it shows what can happen when a robust school board procedure is followed properly. So this is the case of Moms for Liberty of Wayne County versus New York State Education Department.
New York always does their naming stuff weirdly, don't they?
Do they?
Yeah, because it's the State Education Department, not the Department of Education. No, don't get confused.
Yeah, New York. Come on,
Right?
man. Like, get with the program.
They do it just to make our lives harder.
So, spoiler alert, everybody. Moms for Liberty lost this case. I just wanted to kind of throw that out there, and let's talk about why. All right?
Yeah, let's do it.
Okay. Welcome to Chalk and Gavel, everybody, where we explore how the law shapes education one case at a time. I'm Jamie Cudlitz. I'm a former middle school teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, bringing you the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
The kids are alright. The kids are alright. The kids are alright.
Okay, welcome back, everybody. Just a quick reminder, don't forget to rate and review Chalk and Gavel. If you're checking us out on YouTube, please give the video a thumbs up and subscribe to our channel. We have a teaching guide available on our website, chalkandgavel.com, and we would love it if you would consider supporting the show on Patreon for just $2 a month. Go to patreon.com/chalkandgavel to help keep us bringing you this great education law content. All right, well, let's get into it. What's our bell ringer today, sir?
I've actually got two.
Come on.
See, look at the value.
Look at that.
You're
Look what
getting.
your money is getting you, folks.
Huh? So the first one is really quick. So the Fifth Circuit has agreed to hear the Louisianna 10 Commandments case that we covered in episode 51
Hey,
on Bonk.
I'm not really surprised that
I know.
it's still dragging on. So on Bonk, Chris, they're all of them.
Yeah, so that means that the panel decision that we talked about in episode 51 has been vacated, meaning that it's no longer good law because now we just have to wait to see what the Fifth Circuit on Bonk has to say about the
Is that what that means?
constitutionality of the 10 Commandments. What's
Is that what that means? Like before they've decided or before they've actually heard and ruled on it, they toss out the earlier decision?
As if it never happened.
Really?
Yeah. So when they agree to hear it on Bonk, they vacate the lower court opinion or the panel decision.
The panel decision. So it reverts back to the trial court level?
No, it's just on appeal.
So what decision is in place right now?
The lower court one.
That's what I mean. Right?
Yeah.
Yeah. Okay.
So, that's the gift that keeps on giving.
Yeah.
I'm starting to think this one's probably going to make it to the Supreme Court at this point. Because, well, I don't know. I didn't think Oklahoma and their virtual religious charter school was going to make it, but now I've decided I'm not going to make predictions anymore. So we'll see what happens.
Okay, that's interesting.
The other one I've got is an update to our case from episode 27. So going back a little bit further, this was Kluge versus Brownsburg Community Schools. So this was the case of the music teacher who refused to use the names and pronouns listed in the school's database for transgender students due to his sincerely held religious beliefs. So he was let go by the school. And when we talked about it in episode 27, we were talking about the trial court's decision, which was actually the second time the trial court had done it because it's already gone up and down once. And the trial court in that decision upheld the school's decision to let the teacher go, basically saying that, no, you didn't violate his First Amendment rights, his religious freedoms, or fail to reasonably accommodate his religious beliefs by like allowing him to call students by their last name only, stuff like that under Title VII.
Yeah.
So it got up to the Seventh Circuit and they chimed in on appeal over the summer and they remanded the case back to the trial court due to their view that there were still some factual questions that needed to be answered. So the Seventh Circuit, I know, it's another round. Like this one's already gone up and down once. So this is like, if you're keeping score, this is the third time the trial court is looking at the case. But for the Seventh Circuit, they emphasized that for them, at least, there wasn't enough evidence of the school's goal or their school's like stated mission or purpose of ensuring an inclusive and welcoming environment for all students. They basically kind of just said like, you didn't put on enough evidence of that, or you know, we need to make sure that that's really like what it is you're trying to do. And then we also need to be sure that Kluge's behavior undermined that interest. So it kind of goes to this question of like, did the school do a sufficient enough job of kind of like articulating its interests leading up to everything that had happened? And two, did they do a good enough job documenting everything that was going on and the impacts that it was having on students and how it was actually undermining their interests and their values and their educational mission? And so, you know, Jamie, you and I like to say document, right? Like that's exactly what we're meaning, because this is a question of like, can you put on enough evidence that any sort of accommodation you would offer to Kluge, you know, because I think they tried the last name only approach for about a year, and like a bunch of students came out and said like, look, that denied me my education. Like I didn't feel included. I didn't feel valued. Exactly.
It feels like it's all like a mask for this teacher's, in their minds, prejudice, I guess.
Yeah. Like you know, there was something there that was keeping these students from being full participants in the classroom. Okay. Right. And so, you know, I think the school here has the receipts. It's just a question of like,
did they bring them?
Did they bring them? And, you know, at what stage of the process do you get to show your receipts? So like, I forget exactly where we are in the process, but like, you know, if they're remanding for these evidentiary concerns, I think we're at a motion to dismiss. So, you know, it has to be undisputed facts. So there's disputed facts. So that means we're going to trial.
Okay.
Another round.
Here we go. Another round. Awesome. 2 bell ringers for the price of 1, or none if you're not paying. All right.
But you are, because you subscribe to our Patreon.
That's right. All right. So let's get into today's case. So this is a topic that we've been covering for a while. So we've talked a lot about controversies over books in school libraries. Over the last few years, we've seen like dozens of new laws across the country addressing procedures for library challenges, restrictions on the content that's appropriate for school libraries, lawsuits from every angle around this issue. And some of the big points of emphasis for these laws have been inappropriate material or content of a sexual nature, though critics of those laws often point out that these laws and challenges are often aimed at LGBTQ inclusive books, or books that include minority voices or perspectives. Like those books seem to be uniquely targeted, I guess you could say, in a lot of these laws. Right.
Yeah. We've been tracking this since before Chalk and Gavel, like 2022. It really kind of took off. Florida did their parental rights law.
Yeah. And then a lot of the rest of us followed suit.
Yep. That's right. So like these controversies over school library books has been a huge issue that has led to a lot of litigation. Go figure.
Exactly. Exactly. So, well, and today's case is just another one.
Yeah.
All right.
Though it's got an interesting twist.
It does. It does. Today's case asks an interesting question that I don't think we've covered yet. So what happens when a school rejects a parent's challenge to the books in the library?
Right.
Yeah, that's
right.
right.
Usually we're talking about schools who do remove the books or laws that require them to remove the books.
Yes.
But now we've got books that are staying on the shelves.
Exactly. And so in this case, we've got a challenge. We've got the school denying the challenge, basically. And let's see what happens. So
I bet we have some unhappy parents.
Well, there's your, we already spoiled it and said Moms for Liberty lost here. But
also,
we're going to talk about why, because it's really important to kind of understand how this thing played out for, teachers and principals and school district leaders, because you're probably dealing with stuff like this.
Yeah.
Right?
I joked about the unhappy parents, but like, this is one of those situations where you're kind of, no matter what you do, someone's not going to be that happy about it.
Yeah.
Right. Like, which is kind of the definition of leadership in a lot of ways.
Exactly. So today our case takes place in New York State in the city of Clyde, which is it's upstate New York-ish near Lake Ontario. It's kind of halfway between Syracuse and Rochester.
Okay.
All right. So I'm sure it's gorgeous, especially this time of year in the fall. I bet you it's beautiful in Clyde. So
field trip.
Yeah, let's go. So our story begins in April of 2023 when the Reverend Jacob Marchitel, that is, I'm assuming that's how you pronounce his last name, Marchitel, was a parent in the Clyde Savannah Central School District, showed up at a school board meeting, again, April 2023, showed up to the school board meeting to challenge 3 books in the school district's junior and senior high school libraries.
Okay. So right around that time frame we were talking about.
Exactly. So the 3 books in question were People Kill People by Ellen Hopkins, It Ends With Us by Colleen Hoover, and All Boys Aren't Blue by George M. Johnson.
Okay.
All right. And the next month, he wasn't done. He showed up again at the next board meeting and added 2 more books to the list. All right.
Okay.
Yeah.
Do you know any of these books? I don't know any of these books.
Actually, I don't. No.
Okay.
I have not read any of these books. So now we've got a total of 5 books that Marchitel is challenging. All right. The books, all of them, had been selected by the district's media specialist for inclusion in the library. There's no evidence that these were used as a part of the curriculum.
Mm-hmm.
Okay. At least it didn't say anything in the court opinion about that. So all we know right now is these were just books that existed in the library. Now, Marchitel went through the district's formal procedures for challenging books. He submitted his objections in writing. So that was part of the process. You got a problem with books? Fill out this form.
I'm so happy there was a process.
Oh yeah. Well,
that makes me so happy. This entire case makes me happy, but
well, that's because the whole entire case hinges on this process, essentially. So he submits his objections in writing, and here was his reasoning. He said, in his view, the books contained profanity and sexually explicit content, which he viewed as, quote, deviant and criminal sexual behavior, unquote, according to the court opinion. Okay. And so the bottom line here is what we have are some potentially problematic books. And we need to remember that a large portion of what governs all of this is based on the Pico case from the 80s that we've talked about a bit before on the show when we have talked about all these different book bans. So long story short, from Pico, it more or less said that you can't censor books just because they have stuff in them that you don't agree with or that you don't like. Okay. But you can, if the books are not pedagogically appropriate or they're not age or developmentally appropriate, there's a little bit more flexibility there to deal with that kind of stuff. So lots of this current book ban stuff that we've been talking about, as we mentioned, centers a lot on this sort of subjective nature of what's appropriate, right?
Right. Yeah. Though there are questions about the force and effect of PICO. So that's actually a big piece of this case is like, what does PICO mean? Because PICO was not a clean majority opinion.
No, it was like 5-4 or something, right? Like it was,
the outcome was 5-4, but no 5 justices agreed on why or what to do and how to do it. So like there's a plurality opinion, but plurality opinions, easy for me to say, aren't binding precedent. So so
and
there's a question there about like how strong of an obligation is
do we
that
have
idea?
Yeah, of PICO. Yeah.
Mm-hmm.
Yeah. And I think that's, that's an important point. I think we've made that point on the show before is that even binding precedent is not binding precedent anymore,
Well,
right?
It all depends on what it means too, right? Because we've talked about that, like so much of the ongoing legal challenges that we're having is basically like arguments about how to interpret existing precedent, even if you're not actively changing it, which we're also doing that right now too. So like,
So like even 8-1 decisions or 7-2 decisions or whatever, like they're not always necessarily binding precedent. And in this case, in the PICO case, 5-4 and with a whole bunch of different opinions, it's on shaky ground, I guess is a good, a good way to put it. So
the water is muddy.
That's exactly right. So anyway, it's important to reinforce here. One of the things I really want to reinforce is that the district had policies and structures in place to attempt to address these kinds of situations, these challenges. Okay.
Beautiful.
Yeah. As I mentioned, there was a requirement to submit a challenge in writing, which Marchitel did. And that triggered the next formal step in the process, which was appointing a review committee to look into those 5 challenged books. Okay. And they were tasked with providing a written report on each book. Okay. Book reports.
Oh, yay.
Yeah. They had to do book reports.
I appreciate that we're giving the teachers homework.
That's right. So it's important to note here that the person who selected the books in the first place, which was the district's media specialist, was the only mandatory member of the review committee.
Okay.
So I kind of like, I read into that what you will. It didn't really discuss that in the court opinion, but the person who selected the books is a mandatory member of the committee. I think given the person's position and their potential expertise, it makes perfect sense. But I'm sure there's somebody out there who's going to listen to that and say, hey, that's a conflict of interest.
Right, because they're reviewing their own decision. But
that's why there's 4 other members of this committee. Okay. So you ask, who were the other members of the committee?
Who were they?
Oh, thank you for asking that. The other members of the committee were the Director of Curriculum Instruction and Educational Services, the high
that
school
sounds like
principal.
an important position.
It does. The high school principal, the junior high principal, the chair of the English department, and what is described in the court opinion as a, quote, process consultant.
I.e. the lawyer.
Is that what you think?
That's just how I read that. Like there was a lawyer in the room to make sure they got things right. Or to make sure they did it right.
Maybe it was a lawyer, maybe not. We don't know based on the court opinion.
I read that and I immediately I was like, that's got to be a lawyer, but we're not sure. Right. Yeah.
So that was not the first thing that came to my mind, but the first thing that did come to my mind was this person, whoever it is there to ensure that the right boxes get checked, that the process is done properly,
that the I's are crossed and the T's are dotted.
Yeah, which is very smart. So aside from that member, it sounds like the other members of the committee are, I think arguably you could call them experts. Yeah. You've got 2 principals, you've got the chair of the English department, you've got the director of curriculum and instruction and in educational services, and you've got the district's media specialist. So if there's any group that can pedagogically sort of really review and analyze curricular materials, it's not a bad start.
Right. Yeah. The only thing that I would say would be potentially missing is so much of this revolves around community values as well.
Yeah.
Like maybe community members or parents, but
100%.
like you said, if I'm looking at the pedagogical value of these books, that's the committee I want doing it.
Yes. Yeah. Now, like you said, could it have been a little bit better or a little bit more robust with community involvement. Maybe something to consider, something to think about, food for thought. Okay, so here's what happened. The committee reviewed book reviews, awards that the books might have gotten, ratings, whether or not the books were available in other school districts. So they did their homework. I'm assuming that they also read the books.
Important.
Yeah, exactly. But like the court opinion said that they reviewed all these other sort of external aspects of these books. And so I'm assuming they also read the books. They followed a rubric and district policies that existed around the review or existed to sort of govern the review process or provided a framework for the review process, something like that. There were rubrics, there were district policies that basically gave the review committee direction for how to go about this process.
Great.
Yeah, which is awesome. So what ended up happening was they described themes, which included in each of the books, which included diverse relationships, gender identity, discrimination, domestic violence, bullying, religion, social awareness. These were all themes that came up.
Which kind of aligns with what we said earlier about like some of the motives behind some of these challenges or the content that is being particularly targeted.
Right. And these themes, they can be tough topics to address in schools, right? And I think it's both because of the heavy nature of those topics, but also because of, like you said, sort of how polarizing those topics
For sure.
are.
Right.
Right. Anyway, so they go through the whole review process. And at the end of the day, which I think was at some point over the summer, remember the challenges started in April of 2023. So I think it was at some point over the summer of 2023, the committee made their recommendations to the school board. And that recommendation was that all 5 books should stay in the libraries. Some should be placed, 3 of them should be placed in the young adult section of the library, and 2 of them should be designated for the adult section of the library.
Nice.
So the committee recommended that all the books stay, but these books should go over here and those books should go over there.
Okay. Probably recognizing some like age appropriateness concerns or like who's the right audience for the books. Okay.
Now, it didn't say whether or not those books were placed in those sections initially, like to begin with, when they were initially put in there. I don't know. So I don't know if the review committee's decision about where those books should go deviated at all from where they were to begin with. I'm not really sure, but that was the end result.
Okay.
And then we're all done, right? No.
Never.
But wait, Chris, there's more.
Always. There's always more.
Despite the committee's recommendations, the school board voted 4-3 in August to remove the books.
Okay. So it sounds like the procedure has some sort of like the school board makes the ultimate decision, but like there's a recommendation and, you know, school boards don't have to follow, like nobody has to follow the recommendation, but
Correct.
When you don't follow the recommendation, like it's a bad look. You got to justify why you're not following the recommendation, right?
Yes.
Yeah. Okay.
And I don't know if they really did that very well because, wait, there's more again.
Okay.
In September, so like a month after that decision, and potentially after checking with their lawyer. Good idea. Should have
always
done
a
it
good
the first
idea.
time.
And I think a couple of them even mentioned like, hey, after we got some legal advice.
Yeah. So after all that, the board voted 6-2 to take back their earlier decision.
Whoops.
Yeah. And the language that the board used when they made that flip was upon further consideration.
We thought about it and we done messed up.
Yeah. Now that we've had a few minutes to kind of think about this, and our lawyer told us that we probably made a bad decision.
Where did the extra vote come from?
Yeah, I was looking at that.
It was 4-3 and then it was 6-2.
Yeah, somebody must have been on vacation in August or something.
Okay.
Yeah. So
whatever.
So one of the things that the board mentioned was that the review committee followed board policy. So this is the second time, right? When they decided, okay, we're gonna take back our earlier decision and we're going to let the books stay. The reasoning that the board gave there was the review committee followed our policy. They did exactly what we asked them to do. And the board saw no reason, at least at that point,
At least the second time.
right, to go against the committee's recommendations.
Okay.
So, I don't know. To me, it, again, sounds a lot like a lawyer approached them and said, dude, what you guys did in August, stupid move. I don't know if he used those formal legal terms, but
yeah.
you know.
Let's reconsider that decision.
Yeah.
Let's revisit this.
So you could say, Chris, that the board finally got on board.
I see what you did there. I like it.
You're welcome. Okay. In all seriousness, Marchitel was not happy with that outcome, obviously. So he appealed to the Commissioner of Education, which was part of a state law process. If you don't like a decision of a school board, there's a process for you to go through here.
Okay, nice.
All right.
So it's an administrative review process.
Yeah, I think it sounded to me like when I read it that it sounds like one of those diet court things again, right, Chris?
Very much so, yeah.
Yeah. So it's like a process that seems to mirror formal legal proceedings like filing submissions, friend of the court briefs, which is amicus or whatever you want to, however you want to, amici. Those are the where interested parties try to weigh in on behalf of one side or the other and provide their own reasoning for why they feel like a decision should go this way or that way. And then the Commissioner of Education weighs everything and makes a decision, which is kind of like what a judge or a panel of judges would do, right? So diet court.
Yeah, diet court.
Okay. So that whole process takes place. All right. At this point, this is where Moms for Liberty jumps into the whole story.
Right.
All right. So Marchitel is now joined by Moms for Liberty.
Who's been part of this whole conversation.
Yeah.
Like,
since day
they've
one.
been very active in challenging a lot of these books and pushing a lot of these laws.
Yeah. So this is their wheelhouse, I guess you could say. So ultimately, though, the commissioner sided with the school board, at least the most recent school board decision.
The second time.
The second time.
Yeah.
So here's where things, to me, start to get a little interesting. I mean, it's been interesting up until now, but like this is where it gets a little more interesting. So Marchitel claimed that, quote, the books are per se inappropriate as they are pornographic. They serve no educational purpose and are potentially illegal obscenity.
Oh, that's a really high bar, dude.
And they also argued that the board failed to apply proper pedagogical and ethical standards and relied on a mischaracterization of the First Amendment.
Oh, okay.
So that was the argument that Marchitel and Moms for Liberty were making. Pornographic, no educational purpose, potentially illegal, obscenity depicted in the books, and that the board's procedures sucked, essentially.
Yeah. Okay.
Right?
And probably like the books weren't age appropriate for all of these reasons, right?
Right.
Yeah.
So the commissioner reviewed all that and basically called BS on it.
Okay.
Said, no, I disagree.
Was
and
that in
he
the
said,
opinion?
No, I did not see BS in the opinion. I looked very hard for it. And I was disappointed when I did not find it. But this is my
Sometimes I think courts need like...
They need us, man.
I was going to say they need like the Key and Peele like anger translator. Do you remember that?
I would not
like,
put us on the same level as Key and Peele.
Well,
but I would love to see Key and Peele involved.
I just put us in the same sentence. You're making that judgment statement.
I don't even think we belong in the same sentence, man. like that's some funny stuff. We are not. Okay. So anyway.
We've got teacher humor.
Yeah, I know, right? Okay. So the commissioner did not sign on to that particular argument. And the commissioner said that the board has broad authority to pick materials for their schools as long as they apply fundamental constitutional safeguards. Now, the commissioner viewed those constitutional safeguards as coming from
Pico.
That's right. We talked about it. The language in the Pico case about not removing books just because you disagree with their ideas that was what the commissioner kind of jumped onto. That was the argument that they pulled. The commissioner didn't deny that there was profanity in the books, didn't deny that there were other counts of sexual interactions, things like that. But he said that Marchitel, quote, failed to demonstrate that the books lacked literary, artistic, political, or scientific value.
Interesting. Okay.
Yeah.
And so like it's a balancing here. Like, yeah, it's got that stuff, but it also has these other values, which is how courts have handled obscenity issues.
Yeah. It's not
outside of the school library context.
Yeah. It's not just obscene for the sake of being obscene. Right? There are other lessons in there. There are messages that potentially the obscenity is a vehicle to help deliver those larger goals or objectives, right? I don't know if that's a great way to say it, but it's like the obscenity or whatever is in service of these more noble curricular pedagogical kinds of aims.
Yeah. Yeah.
Right.
No, I think that's perfect.
Thank you. So Marchitel also said that there were studies that showed that early exposure to these types of content, right? The sexual nature, obscenity and all that stuff, that there were studies that showed that that stuff was harmful to kids. Okay.
Yeah, okay.
And basically what the commissioner did at this point was they fell back onto the First Amendment, saying that, quote, no academic study in any event could abrogate students' right to receive information and ideas through school library materials.
Yeah. Okay.
So
Pico right there, front and
Pico
center.
right there. But he's basically saying, like, listen, we're talking about apples and oranges here. You're talking about studies that say that this is harmful to children. And I am talking about there's no studies that say that students should not have the right to receive information.
Right.
I mean, maybe it's not apples and oranges. Maybe it's, this kind of apple versus that kind of apple, right?
Yeah.
Yeah. So he went on to say in response to the sexual deviancy claim that, quote, boards of education lack authority under the First Amendment to prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion. Basically saying, unquote, you might think this is sexually deviant, but that's just your opinion. And the boards are not allowed to really insert their opinions that might
just like
disagree.
your opinion,
This is
man.
That's right, man. Anyway, I was thinking about dressing up as the dude for Halloween.
We should do a Halloween episode because
we should. The next few are going to be interesting, right, Chris?
Uh-huh.
Even though this episode, that we're talking is coming out after Halloween.
After Halloween, right. Yeah.
Yeah. Anyway, all right.
It's going to get really confusing in December.
Yeah, I know. Why does Chris look like that? That's a teaser. You'll see why in a few episodes. So the end result there is they go through this whole review process, and once again, Marchitel and the Moms for Liberty, they lose. The commissioner at this sort of highest level of educational review sides with the school board and allows the books to stay. Then what happened?
Well, and then they filed a lawsuit.
Yay.
So in April of 2024, Marchitel and Moms for Liberty seek judicial review of the commissioner's decision in New York State Court.
Okay.
So they have kind of the same claims. They're basically claiming that the commissioner's decision upholding the school's determination to keep the books was arbitrary. It was an abuse of discretion.
Arbitrary.
Arbitrary. Yeah, meaning it had no reasonable or rational basis.
Except for a giant procedure that existed.
Well, I'm not saying it's a good argument, Jamie.
Oh, okay. Sorry. I'm getting ahead of us. Sorry. Keep going.
Sure. And they renew their arguments about the misapplication of the First Amendment, particularly the overreading of Pico. And so they're seeking an injunction to prevent the school from shelving the challenged books.
Okay. All right.
Yeah. And the school had the same reaction as Jamie and immediately filed a motion to dismiss the claim.
A 12B6.
A 12B6, except you would think that, but we're in state court in New York. So the federal rules of civil procedure don't apply to state courts. So this is actually New York Civil Practice Laws and Rules, section 3211.
Okay. That's just the state equivalent of a 12b6, right?
Basically. Yeah.
Okay. All right. So I'm still going to say my answer was accurate.
So the court's ruling on this motion to dismiss, and the first question the court is asking is whether the decision to uphold these books was arbitrary and capricious.
Okay.
We've talked about this in other contexts, but like all governmental action has to be reasonable. That's kind of like the baseline. In my classes, when I teach this stuff, I call that the legal baseline. If there's no other law or legal protections that apply, it still has to be reasonable.
Yeah.
And so sometimes you'll hear this called like the rational basis test, where there has to be governmental action has to be reasonably related to a legitimate governmental interest.
Yeah.
If it's not reasonable, then like, hey, that's a problem because we don't want the government to be doing arbitrary things for no good reason.
Yeah. And so just,
Makes sense.
a quick example to illustrate this, we'll go back to the Bong Hits for Jesus case that we covered, about a year ago or something. The school has an interest in not promoting illegal drug use, right? So it can act to suppress speech that promotes illegal drug use. So, the school has an interest in suppressing that speech because it's related to part of its mission, right?
Right. Except the First Amendment would add additional protections there. So because the First Amendment there, like we were past the legal baseline. But if there was another situation like that was regulating conduct that had nothing to do with speech, like then, yeah, like, hey, if your goal is to end illegal drug use and you pass a law that you can't have a vape pen in school, like, yeah, that seems pretty reasonable. Let's let it go because there's a rational relationship between a legitimate interest.
Mm-hmm. Mm-hmm.
Right?
Okay.
And so that's the baseline.
Okay.
Everything has to have that rational basis. If it doesn't, it's arbitrary and capricious. So in New York, the way the court kind of explains that is that all government decisions have to be reasonable. That doesn't mean it has to be like the only choice or the right answer or the perfect solution. It doesn't have to be the one that the court would have chosen.
Okay.
It just has to be
Reasonable.
one of the reasonable options available.
Okay.
And the court emphasizes that schools have wide discretion within all of this. And so when reviewing these educational decisions, courts typically tread pretty lightly and they won't second guess those decisions because of the experience and expertise that the educators have that courts just don't have, right?
Yeah. So as long as they just figure out that it meets that reasonableness baseline, they're not going to really go into
They're
this
not
any
going to
further.
second guess it.
Yeah.
100%.
Okay.
And, there's lots of reasons for this. We've talked about it before, like local control, ensuring that schools are run by the people who are most impacted by them, who have the most experience, most expertise in all of this stuff, protects academic freedom. It makes sure that courts stay in their lane, right?
Mm-hmm.
Like we don't want courts to be making educational policy necessarily.
Right.
So for all of those reasons, courts typically defer to the sound educational judgment of school personnel, unless there's these other constitutional things that we've talked about too, right?
Mm-hmm.
So with all of that in mind, you can probably guess which way the court went on all of this, given that context. The court concludes that, yeah, you know what? The decision to keep the books, that was not arbitrary or capricious.
Okay.
And
fair.
you know why?
Unsurprising. Why?
Unsurprising. Because the board followed their procedures.
Oh, yeah.
I know.
Yeah.
It's amazing.
Look
That's
at
the punchline.
Look at that. Okay. All right. So
There were procedures. They followed them. They made a review committee. The review committee was full of experts. They read the books. They looked at how the books were received. They looked at how widely read they were. They
had
assessed
a
the
rubric.
books
Yeah.
against the rubric.
Yeah.
They even wrote book reports.
Yeah. Yeah.
And as the attorney, this makes me so happy because it's so nice to get a case file on your desk to see that the school had a procedure, followed the procedure, and explained what it did and why, and have documents to back that up.
We always,
that makes me so happy.
And we always say on this show, know your procedures, know your things. Well, part 2 of that is follow them.
Right.
Right.
Know your procedures, follow your procedures,
follow them.
document.
Yeah.
If you do those 3 things, you're probably going to be good. in most situations.
Yeah, exactly.
So given everything the school did and how they explained and justified their decision to keep the books, the court concluded that it would be, quote, hard pressed to find that the commissioner acted arbitrarily and capriciously when it sustained the school board's resolution to accept the unanimous recommendation to keep the books on the library shelves. So
unanimous by the review committee, not by the
review committee, not by the school board, right?
Yeah. Okay.
And the court does the same thing the commissioner did. Like, they acknowledge that, like, hey, yeah, there's some stuff in these books that, like, you know, I might not like, but that doesn't change the judgment of these educational experts who said that it has pedagogical, educational, cultural value.
Yep.
And so
that makes sense.
I'm not going to disrupt that.
Okay.
The parents, though, have that other argument about the misreading and misapplication of the First Amendment.
Right.
And
which is like, we talked about how this is already sort of muddy water territory, right? Because they're sort of, everybody's sort of referencing PICO here, which is the muddy First Amendment kind of, landscape. Yeah.
Right. Yeah. And so PICO was a bunch of students challenged a school's decision to take some library books off the shelves based on parental complaints, based on their content.
Yep.
And the 9 justices of the Supreme Court couldn't decide how to deal with that. Or at least a majority of them couldn't agree on how to deal with that. Yeah. And so because of that, there's this big question about the binding effect of PICO. And so for this trial court, like the question of like how much force and effect do we give PICO, this trial court's answer in New York, at least, is not a lot. And I don't necessarily think I agree with that, but for the court, at least, you know, they went through all the opinions in PICO, kind of counted the votes for who voted for which rationale, essentially. And the court finds that PICO is persuasive, but not necessarily binding authority for some of this stuff. And so they kind of identify 2 places where they think the commissioner overread PICO. So the first one is the trial court here takes issue with a statement by the commissioner that said, quote, no academic study in any event can abrogate students' right to receive information and ideas. And so for the court, that sweeps too broadly because it recognizes a like kind of an unassailable right that he thinks is kind of not quite as broad as the commissioner makes it out to be.
Right.
And, you know, maybe not.
Yeah.
But the second one is the court says that it's inaccurate to cite PICO for the proposition that, quote, boards of education lack authority under the First Amendment to prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion. Now, that one I know they got wrong, says the professor who's not a judge. But that language doesn't come from PICO. That language comes from West Virginia v. Barnett.
Oh,
the 1943 flag salute case, where the Supreme Court said, if there's any fixed star in our constitutional constellation, it's that no officer, high or petty, shall prescribe what shall be orthodox.
Yeah.
And then it goes on to say those things, right? Like, and you know, Barnett might be one of my favorite Supreme Court opinions, so I'm going to defend it. While that might not have been the ruling of PICO, it was the ruling of Barnett. So ultimately, none of this actually matters, though.
And why not, Chris?
Because the court says that, like, yeah, you know, the commissioner might have overread PICO, but that doesn't change the outcome here, right? Like, because Jamie, to your apples and oranges point, we're just looking to see if the school abused its discretion, if it acted arbitrarily and capriciously. Like, the board can decide what it wants to do as long as it doesn't violate someone's rights. And here, it's the student's right to receive information, which they kept the books on the shelves, so that right isn't even implicated.
Exactly.
So therefore, like,
nobody
it doesn't
lost
really matter.
Their right. Yeah.
Yeah, exactly. And so because of that, like, this is a reasonable decision. There's more than enough here to kind of say that, like, the school did what they were supposed to do.
Right.
They followed their procedure. No, like, no harm, no foul based on the PICO issues. So the court grants the motion to dismiss and dismisses the parents' complaint and the case in its entirety. School wins. Books stay on the shelves.
Oh man, there you go. Like, so we've got a case where books were challenged and books ended up staying on the shelves, and it was largely due to a very thorough, robust set of procedures that were in place.
And a procedural consultant somewhere floating in the background.
Who was possibly a lawyer. So Yeah, know your policies, follow your policies, document, and, your lawyer can sometimes be your friend.
What are you talking about sometimes? No, when I was an attorney, I always joked, I'm like, I know you don't want to talk to me. I know no one likes it when I walk into a room, and I don't take that personally. But I'm here for a reason, guys.
That's right. I'm here to help you. I'm here for you. Oh, man. Great case. Thanks for pulling that one, Chris. What is our homework?
Your homework is to review your policies and procedures.
If you didn't see that one coming.
Right? Yeah. And then document that you have done your homework by liking, rating, reviewing, subscribing to Chalk and Gavel wherever you get your podcasts.
Right.
You can also find us at chalkandgavel.com or on social media at Chalk and Gavel, on Patreon, patreon.com/chalkandgavel. We love your support, and we're so excited that so many people have engaged with Chalk and Gavel over the years, and we look forward to keeping this going with your generous support.
Yes. So thank you for listening once again, everybody, and we'll see you in 2 weeks. Have a good one.